Ms. Westerkamp, are you familiar with the term performance improvement plan, sometimes referred to as a PIP?
Yes.
Would you agree that employees subject to a PIP are essentially being notified that some aspect of their performance is unacceptable?
Yes.
Have you ever been subject to a performance improvement plan in your time at the Department of Justice?
No, sir. Senator, I have received excellent ratings.
So there's never been any issue your superiors or supervisors have had that required anything like a performance improvement plan?
No, Senator.
Thank you. Lane, I wanted to ask you about your experience trying cases. Have you ever tried a case to a verdict before a jury?
Senator, I've worked on a bench trial, and as a federal law clerk, I handled 7 trials.
I was a federal law clerk as well. I wouldn't say that I handled the trials. I think the judge handled the trials. But let me ask you about your experience with the bench trial. Were you the lead counsel in that case?
No, Senator, I was part of a small team of attorneys.
And were you the senior or associate counsel on the case?
Yes, Senator, I was an associate on the case. There were 4 attorneys on the case. I was responsible for helping prepare witnesses, helping second chair depositions. I also took a deposition myself. I cross-examined a witness at trial, and I was responsible for all the pretrial and post-trial briefing, findings of facts, conclusions of law.
And of the 4 attorneys, how many were more senior to you on that team?
Senator, I believe 2. There were several people who came in to assist, but again, my responsibilities, I was the primary drafter for all the briefing.
No, I heard that. I just want to understand. So your trial experience consists of being the second or third senior lawyer on a bench trial?
Senator, yes, it was a week-long trial involving complicated constitutional issues, and my role, again, was I helped draft and prepare all the briefing.
But you've never done jury selection, never done voir dire, for example?
When I was a law clerk, Senator, 5 of the trials before the judge who I clerked for were jury trials, and so I had the opportunity.
And I was a law clerk. It was a great experience, but I didn't pick the jury when I was a law clerk. I didn't question the jurors. I didn't seek to use a peremptory or other challenge for cause for a juror. That's really not the role of a law clerk. You observe it, but you don't do it yourself. And so have you, apart from the bench trial, have you cross-examined witnesses in any kind of other jury trial or any jury trial?
Senator, in that case, I cross-examined a lay witness. I also deposed an expert, and I was...
Never before a jury. Have you ever filed or argued a motion to limine?
Yes, Senator, I've, in that matter, handled several motions in limine as well as in other matters, particularly at preliminary injunction stage. Some of the litigation I've been involved with has had extensive evidentiary records at the preliminary injunction stage. So I've filed and handled several motions, many motions in limine, Senator.
Many motions in limine in that one bench trial?
Yes, Senator. In that one bench trial, I handled several motions in limine, but I've also handled motions in limine in other litigation, again, more at the preliminary injunction stage, seeking to establish a clear record going into a preliminary injunction hearing where there may be live witnesses, evidentiary issues, kind of at that initial stage.
Okay, thank you. I'm not trying to denigrate your experience as a law clerk. I think it's a great experience, and I highly encourage those graduating from law school to pursue clerkships. But having tried cases as an assistant U.S. attorney, it's not the same thing to observe them and to do them yourself. I'm sure you would agree. But thank you. I appreciate it. And Mr. Chairman, I yield back.
Thank you.
Congressional confirmation hearings for lifetime judicial appointments serve as a rigorous competency audit, where a nominee's practical experience is weighed against the demands of the federal bench. On March 25, 2026, the Senate Judiciary Committee highlighted this tension as Senator Adam Schiff questioned Kathleen Lane, the nominee for the District of Montana. To understand the 2026 judicial landscape, we must analyze the specific arguments regarding trial readiness and the evidentiary standards required to manage a federal courtroom effectively. A central theme of this hearing was practical versus observational experience. Senator Schiff, a former assistant U.S. attorney, focused on the nominee's lack of first-chair trial experience. From an educational perspective, this illustrates the lead counsel threshold. While Lane cited her time as a federal law clerk and her role in a complicated 2025 bench trial, the hearing examined whether these roles translate to the reflexive rulings required of a presiding judge. For the viewer, the takeaway is the ABA rating conflict. The American Bar Association rated Lane not qualified, citing her less than 9 years of practice and the fact that she has never conducted jury selection or led a jury trial to verdict. This creates a landmark debate in 2026 over whether exceptional clerkship experience can substitute for the traditional 12-year practice standard. The discourse then shifted to professional conduct and the PIP inquiry. In a notable line of questioning, Senator Schiff asked Lane if she had ever been subject to a performance improvement plan, PIP, during her tenure at the Department of Justice. While Lane stated she had only received excellent ratings, the inquiry underscores the character and fitness requirements of the confirmation process. In the 2026 judicial cycle, any history of administrative sanctions or performance issues is viewed as a red flag for a lifetime appointment, where judicial temperament and a consistent record of excellence are paramount. A particularly technical portion of the hearing involved trial mechanics and motions in limine. Senator Schiff pressed the nominee on her familiarity with voir dire, the process of jury selection, and peremptory challenges. From a legal standpoint, these are the foundational tools of a trial judge. Lane argued that her work on constitutional bench trials and her drafting of findings of fact provided the necessary background. However, the educational link here is the jury trial distinction. Unlike bench trials, jury trials require a judge to make split-second decisions on the admissibility of evidence and potential juror bias. The 2026 oversight standard emphasizes that a district judge, acting as the gatekeeper of evidence, must be wholly conversant with these complexities before taking the oath. The hearing also addressed institutional integrity. Lane's background as Deputy Solicitor General of Montana has made her a focal point for ideological scrutiny. The hearing examined whether her past advocacy on state-level constitutional issues would affect her judicial impartiality. As we have seen throughout early 2026, the Senate is increasingly focused on ensuring that the federal bench remains a neutral forum, especially as originalist interpretations of the Constitution face rigorous challenges in the appellate courts. In summary, the March 2026 Senate Judiciary hearing reveals a profound experience gap in the current wave of judicial nominations. Whether it is debating the role of a law clerk versus a trial lawyer or the validity of an unqualified ABA rating, every exchange is a lesson in how accountability is maintained in the third branch of government. These are not merely partisan talking points, they are the foundational questions that determine the quality of justice in Montana and across the nation. By understanding the link between trial standards, professional ratings, and judicial temperament, viewers gain a clearer view of the legal standards that will define the American judiciary for the next generation.